Okay, so we will now start to discuss the topic of determination of novelty and inventive step. The first question is regarding reason 1 for invalidation in the hypothetical case. The hypothetical case is basically the same as the case used in the earlier mock oral proceedings. So I will explain only the point for reason 1 for invalidation. For details of the hypothetical case, please refer to the case explanation of mock oral proceedings. Invalidation reason 1 is lack of novelty based on publicly worked invention. The point of invalidation reason is whether you can support the argument that the storage container M had been on sale prior to the filing of the application. Also, when examining that, how do you consider A1 through A3 evidence? Now, the question 3. Regarding the invalidation reason 1 in the hypothetical case, can you support the argument that the storage container M had been publicly worked prior to the filing of the patent application? And can you support the invalidation reason 1? If you can support, what kind of judgment should be made to determine whether the A1 invention is publicly worked? If you cannot support, what point of reason 1 for invalidation cannot be supported? Regarding A2 and A3, by adding condition or information, your judgment would be changed. JPO Chief Judge Mr. Morifuji, would you please give us your answer? Thank you. Well, to say the conclusion first, it can be supported. In other words, the invalidation reason 1 is established. As shown in the hypothetical case on page 5, the invention in question is the same as the invention that can be found in A1. That is the assumption. And in addition, regarding A2 and A3, there's no evidence of the falsification has been presented. So with this assumption, JPO recognizes that A1 storage container M was publicly worked prior to the filing of this application, and therefore the reason 1 for invalidation, lack of novelty, is established. So question 3b to 1, let me explain further about the publicly worked nature. The blog entry in A2 can be inferred as the impression on the mouse's storage container M before July 6, 2019, after actually using the product. And the post of the review site, in which is the A3 evidence, we can infer that it was posted before August 6, 2019, and other person before August 18 posted their review comments after purchasing and using the mouse's storage container M. A2, and then the first person, Mr. YY, posted the review comment before August 6, 2019, and the second person, YY, before August 18, posted their review comments after purchasing and using the mouse's storage container M. So regarding the storage container M, A2 and A3 and A1 are identical on the product name, product information, diagonal view, as well as plain view. In addition, A2 and A3 state that the source of this information is the mouse's mail order website. Therefore, it would be natural to assume that the storage container M described in A2 and A3 are the same as the storage container M described in A1. So all things considered, it can be concluded that the storage container M described in A1 was available for purchase or use before August 18, 2019 at the latest, which is the date of the review comment passed by Mr. YY, was the second person. So it was publicly worked prior to the filing of this application. So this is all as my answer. Thank you very much. Next, I would like USPTO Vice Chief Judge, Mr. Dr. Tierney, to answer. Would you please answer?
Yes. So similar to the JPO, when we look at the question here, we're going to make a couple assumptions, which are basically, it appears that it's the same exact document. The A1 mouse product appears to be identical to the A2 and A3, which would be the blog and also the review site. It's not clear that there's any difference been articulated. The question for us comes down to, has what we would call the petitioner, I think you call it the demandee, have they established that the mouse was on sale more than prior to the filing of the application by the patent owner? Here, what we typically see, if all we had were the websites themselves without anything more, we probably wouldn't have enough there to say it was more likely than not, just because they are able to possibly the dates may have been changed on the documents. We don't know for sure that the document date's actually the actual date. However, almost every case we have where there's an internet website that's been brought before us for purposes of printed publication, we have something called the Wayback Archive, Wayback Machine, and what we'll have there, and everyone can use it, obviously, you'll have a declaration from a librarian at the Wayback Archive who will say, we archived this website and this page on X date. And that date will then be confirmed by the declaration, by that Wayback Machine. They're subject to cross-examination, but we do give a lot of credit to the Wayback Machine saying this website was available on that particular date. And they would establish the dates that way. If all you're doing is saying, well, post-application, we were able to access the website, that generally is not enough, because we don't know if the dates were changed. Given the Wayback Machine gives us a confidence to say, yes, this is credible. Therefore, it's been established what the dates are. And as articulated, we haven't seen a difference in the actual mouse product. So we would say, given those conditions, we would find it unpatentable.
Thank you very much. Next to Dr. Beckedel from EPO, please.
Thank you very much. I think that my answer is very similar to the US answer. Allow me a bit of explanation what our test is. When it comes to public prior use, for novelty or even for others, we ask three questions. When has the public prior use occurred? This needs to be specified by the party relying on that public prior use, usually the opponent. Secondly, what was made available to the public? So there needs to be a description of the actual circumstances and also technical information of the product that was sold. And lastly, circumstances of the use. This is also more information about what really happened. Was it just for internal purposes, potentially under confidentiality agreements or anything like that? So on all these 3 points, we would request, or we would expect, not request, we would expect the party relying on public prior use to first of all to describe everything. And now I look at what we got here. For A1 here we do have a problem that there is nothing described upon when the public prior use, when the sale is said to have been occurred. So that would be already on the first point, that would be an issue. On A2, here with A2, either I might have made a mistake in preparation, either it's an internal block, or if it's an external block, then we would have the same issues that were described by the US, and we would expect more information about really when was what really put on the internet. And for A3, here we see a lack of technical features. Having said this, I was only looking now at each and any of those 3 documents individually. They could be combined. I'm not saying that this is excluded, but I would require more information from the party relying upon it. This can be done by an affidavit, can be done by hearing of a witness, can be done by backtracing of internet pages. So all these things happen in real life, but what I have just now on paper here, I would not be very much convinced that there's really a public prior use. If there were public prior use, we could talk about novelty destroying of that container.
Thank you very much. Okay, so we have now the answers from all the three offices. So Mr. Morifuji, what is your take on this? Thank you very much. JPO, as I said in my answer, so the A2 and A3 without the evidence that has been forced, so that the novelty is established. And then USPTO also, I think I understand the same. So the Wayback Machines, like using the Wayback Machine, and if the date is established, and then in that case, the publicly worked in nature can be established. That's my understanding. Is it correct?
That's correct. One little caveat. This is, for purpose of this question, we're assuming it's a PGR, because our inter-parties review, technically we can't do public sale. It had to be on sale would be within the first 9 months of the issuance of the patent. Just wanted to put out that little.
Okay, thank you very much. So let me clarify with the EPO. So maybe hypothetical case may not be understood very well, but A2, A3, if anyone can access to those two. That is on the internet, information on the internet. If you use that assumption, you think that in publicly worked nature is not established.
No, it would still require more information from the party, as was outlined by you two as well. If that information would be evidenced by the party, then the container could well be novelty destroying to the claimed invention. No question about that. But the way to reach that conclusion is still with the opponent relying upon that public prior use. That's a long way, maybe a long way.
Okay, so thank you very much. So based on what you just said, as we put as a summary here on this page, so I think that our answer has been split. Okay, so just generally speaking, so just to clarify once again, I'd like to ask Ms. Dr. Beckedorf from EPO. So the JPO's answer is that from A1 to A3, combining those evidence together, considering them all, this before the filing of the application that this product has been on sale, this fact has been approved and accepted by us. So do you have any concept that, combining all the three evidence and then consider them all at once?
Yes, that's possible. And if the evidence is completed, let's say by witness, then it would be possible to combine all three documents or three pieces of evidence and coming then to the conclusion. The only difference that we discuss here is whether what is on paper right now is already sufficient to be convinced of the public prior use. If those gaps that I described are closed by the parties, by the opponent, then I think on the technical point of view, I would not only accept public prior use, but also the technical relevance of that container, of the Moses container.
Thank you very much. So once again, I'd like to ask the USPTO. So A2 and A3, the container M, and also the container M in A1, if they are identical, in that case, the publicly worked nature will be accepted, right? And also whether it is identical or not, how do you examine or how do you confirm if those three are identical?
Well, that's for the parties to put on the evidence for us. But at least what we're looking for here, what I'd expect from the parties is one, they'll show that the A2 and A3 and even A1 to the best they can The websites were archived. That's going to be the Wayback Machine. That'll establish the dates at which these pictures, the web pages, were actually out there for public dissemination. Once we have that, then it's publicly available. Then the next question becomes, is the mouse container going to read on, or at least what the public version of what we found online, is that going to read on the claim? And when I did a comparison between the claim and the product, it appears to read on the claim from what I'm looking at. A2 and A3 are confirming that it was on sale and also show the similar picture and similar view. So again, I'd have to see if the patent owner has anything for us to take into account, but absent something to show us that it is different than the claim, all things point to the claim reads on that product, or the product reads on the claim.
Okay, thank you very much. So question 3 for the publicly worked nature. So I'd like to stop here. So I'd like to go to the next question.
Let us go on to question 4. From question 4 and onward, we will ask you about the reason for invalidation 2 regarding the hypothetical case. Reason for invalidation 2 is the lack of inventive step described in A4. I will explain the differences between the patented invention and A4 invention. For patented invention, a flap has protrusion, and this protrusion maintains the closed state of the through hole. And A4 invention has flap with no protrusion. Flap portion will fit into the through hole to maintain the closed situation. These are the differences between the patented invention and A4 invention. The key point for invalidation reason 2 is, does the storage container S have the obvious problem of liquid leakage? Regarding the issue, A4 describes the judge's comment. Also, in the oral proceedings, a demandee conducted witness examination. How this information is considered is also a key point in this question. Now, I would like to ask about the reason for invalidation 2. First of all, is this patent invalidated by the reason for invalidation 2? In other words, is this patent something that could have been easily invented from the A4 invention? Mr. Morifuji, Executive Chief Administrative Patent Judge, the floor is yours. So JPO will say yes. JPO believes that reason for invalidation 2 is valid, which means the invention lacks the inventive step. USPTO judge, would you answer with yes or no regarding this question?
Yes.
Yes.
So EPO, Dr. Beckerdorf, yes or no?
It's a yes as well.
Thank you very much. Unfortunately, the reason for invalidation 2 is valid. So we all agree. Now, I would like to hear in detail the reason. So Ms. Tokashi, please go on to question number 4. Now I will ask question 4. Regarding the problem of liquid leakage, the demandant alleged that based on the description of the comment in A4, this problem could have been recognized by a person ordinarily skilled in the art. In response, based on the results of the witness examination, the demandee alleged that the problem could not have been recognized by a person ordinarily skilled in the art. Based on these allegations, regarding the problem with A4 invention, at the time of filing the application for the patent, do you think a person ordinarily skilled in the art could have recognized it? In making the determination, A4's comment and the results of the examination of a witness, how these are taken into consideration. Mr. Morifuji of JPO, the floor is yours. To begin with the conclusion, I don't think the result of the witness examination will be taken into consideration. I will explain in detail. Reason for invalidation 2, alleged by the demandant, is about the lack of inventive step based on A4 described invention. In this hypothetical case, at the time of application for the patent, if A4 is seen by a person ordinarily skilled in the art, can such a person recognize liquid leakage as a problem for A4 invention? This will be the issue in dispute. A4 described the comment, even with the flap closed, when the container was tilted, liquid sometimes leaked from the through hole. A4 describes both comment and details of storage container S as the result of invention competition. Let's say a person ordinarily skilled in the art read this when inventing A4 invention, even with the flap closed. When the container is tilted, liquid sometimes leaked from the through hole. It is natural for such person to understand this way. In this case, how a person ordinarily skilled in the art who read A4 description recognized the storage container S problem will be the key point. So how inventor A who invented storage container S recognized it is not directly relevant. Therefore, the result of witness examination will not be considered in the recognition of the problem. On the other hand, for the person ordinarily skilled in the art who read the comment, applying well-known art to A4 will be a motivation. And the well-known art, in order to prevent water leakage from through hole in natural situation, protrusion is spaced apart from the through hole. Through hole's closed state is maintained by the protrusion, providing such a flap. Therefore, with A4 invention and well-known art, it can be said that this invention can be invented easily. Therefore, it can be said that the lack of inventive step for reason for invalidity 2 is established. So, Dr. Beckett-Dolph, please, could you give us the comment regarding this?
Yes, thank you. As you know, at the EPO we apply the so-called problem-solution approach, and therefore we first establish the distinguishing features. You kindly enough identified those features, and from those distinguishing features we formulate a objective technical problem. And the objective technical problem, and I completely concur with the opinion and assessment that I just heard from the JPO. This is the avoidance of leakage. And then it would be for the skilled, we call it the skilled person in the art, not ordinary, just the skilled person of the art. But the idea of the skilled person of the art is that this is a notional person. It's not a real one. As it is not a real one, this question is not a question of fact, but it is a question that the board can decide at its own motion and its own capacity. As it's not a matter of fact, there cannot be any taking of evidence for that. And that's the reason why a testimony would have no bearing with the EPO on this question. Motivation of the person skilled in the art is an important trigger. There are other triggers like reduction in costs, not only technical motivations, and it can be even other motivations for a person skilled in the art, or the further development in the technology. This, or making it easier, anything like these can be valid motivations that are then taken into consideration. And also, you call it the well-known art. You can also call it this as the common general knowledge. This is an idea that we follow in Europe very much. And the common general knowledge is something that is either in books, books on technologies and textbooks on technology. It can also be in patent literature, but then it must be not just one patent literature, but a series of patent literature that this can be taken into account. To sum it up now, I would, in this particular case, I've already answered the overall question. Here, I would come to the conclusion that the person skilled in the art would choose this solution of a protrusion to apply to the container of A4, and with that, the claimed invention would no longer be, or would already be obvious, and would no longer be inventive. Thank you.
Thank you. So USPTO, Dr. Tieni, would you kindly answer to this?
Yes, thank you. So similar to the JPO and EPO, we come out the same way. We may articulate our standards a little different, but we have the same general process at a high level. So for us, we have several cases. Our Supreme Court has put out a case called Graham versus Deere. Also, we have a case called KSR. And generally what we look for when we're doing obviousness, what is the field of the invention? What is a person of level ordinary skill in the art? What are the differences between the claimed invention and the prior art? Is there a reason to modify the prior art to arrive at the claimed invention? And is there a reasonable expectation of success? Here, it's a very simple invention. We're going to focus on what are the differences. It basically comes down to the flap having a protrusion. For a reason to combine, do we have a reason to combine? Here, if you look at the specification itself of the patentee, figure 5 shows that it was known in the art to use flaps having a protrusion to seal a hole. So we have this reason which, one, the professor, when he tested the prior art product, said you have leakage, which would mean you need to improve upon that product by having a better seal to it. You have then the patent itself showing a suitable seal that one would recognize is going to seal the hole properly with the protrusion. Is it a predictable result? Are you going to have a reasonable expectation of success? Yes. Look at the prior art itself. So given all these factors, we combine, and that's why we come out the same way, EPO and JPO.
Thank you. So we got the answer from 3 offices. Mr. Morifuji, Executive Chief Administrative Judge. So let me confirm one thing. For here, ESPTO.
Yes, it's unpatentable.
So the comment from the witness examination. So they did not recognize the issues. Do you think this will be considered in the examination? JPO, EPO said, no, we will not consider. But USPTO, what do you think? Do you think that they did not consider this the issue of the leakage of the water? But do you think this will be considered as a factor to make the judgment?
The professor's statement would be considered. However, if it was not credible, even without the professor's statement, we still have, as I mentioned, we still have a reason to combine, which is you have a known solution to a problem. Basically what KSR has told us, if you have known elements, such as a flap with a protrusion, you have a hole, you have a lid, those are all known elements. They're being combined for the known reason, which is the flap with the protrusion seals a hole, and it's being combined to achieve a predictable result, which is a flap with a protrusion that seals a hole and prevents leakage. So even without the professor's statement, though would be beneficial because it would go beyond even a higher level of reason to combine, but we don't need the professor's statement to find obviousness.
I understood very well. So let me summarize. What they said will make this chart. Conclusion is the same, but the approach toward the judgment of the steps of the invasion is different. EPO, they use the solution problem process. USPTO also considered the factors in the description. And the next question is also related to this. So I would like to go on.
In this case, I have a question about the reason number 2 for the invalidation. So we have 2 assumptions, 5A and 5B. In each of the case, does it change your answer to the question number 4 if the assumption is adopted? Assumption 5A. There was no statement in A4 that, however, even with the flap closed, liquid sometimes leaked from the through hole when the container was tilted. So it would have been better if this point had been improved. Does your conclusion change if this assumption is adopted? Without this statement, would you change your conclusion? And assumption 5B, a question arises as to the credibility of the inventor A's testimony, and none of the inventor A's testimony can be adopted as evidence. Does it change your conclusion or the answer to the previous question? So starting from Morifuji-san, please. Thank you. So 5A assumption. Without the comment in A4 by the judge of the competition, the demandants claim that the issue of leakage is an obvious issue, that a person skilled in the art would have been naturally recognized is not supported by any specific evidence in the A4. Therefore, unless other evidence is presented, then the demandant's claim may not be adopted. On the other hand, in the JPO's practice, whether or not the invention has an issue that is obvious to those skilled in the art or that can be easily conceived by those skilled in the art is to be grasped based on the state of the art at the time of the filing the application. In other words, the panel will consider not only the descriptions in the prior art documents submitted as evidence, but also documents and technical common sense detected by the panel ex officio to grasp the subject issue of the invention. So, without this statement, the panel will consider and recognize the reason number 2. However, from the demandant standpoint, it is not clear to what extent the panel will investigate ex officio. Therefore, when claiming the issue is obvious, as in this case, a realistic response for the demandant would have to be submitted as evidence, for example, materials published prior to the filing of the application for the invention, and to show the state of the art at the time of the filing of its application on the description in those materials. Now, 5B, in terms of the doubt, the credibility of Ms. A's testimony, as I explained in my answer to Q4, in this case, the results of the witness examination do not directly affect the decision, so I do not believe that the decision would change in case 5B. However, if this case it lacked the incentive step or not would be a very complicated question if the technical field of the food storage is more complicated. And in that case, to understand the level of the technology at the time of the filing application, we may have to refer to the professional's comments at competition. Now, Tiani-san from USB, would you like to give us your comments to these 2 assumptions?
As I said before, even if there's no statement from a professor about the water leakage, here we have a situation where you have known elements combined for the known reason to predict the result. So you still would have at least a reason to combine because you're using, again, if you use a nail versus screw to just be a fastener, unless there's some reason you have an advantage, we would have to have the patent owner explain why there's an advantage to having the protrusion that was unexpected. Here, I can't say it's going to be unexpected that it seals a hole, given that they've already said it's conventional. So that's why I say it's not going to make much difference with 5A, with the question about no professor statement on leakage. Now, as to the inventor testimony, the inventor's testimony, while it's nice to have in a record, it's not really going to be persuasive because it's not really contemporaneous with when the invention was. So it's kind of years later, the inventor saying, okay, when I was doing my invention or that invention of S, here's what I would have realized. But that's, even if that's true, that's not what the record shows. We look for our evidentiary record as to what the document shows, what the actual product would have shown. So the fact she didn't recognize that it had leakage was not going to be dispositive to us. Again, we're just looking at, are we doing a known substitution, which is one protrusion flap for another flap? They're both going to be equivalents, or if there's an unexpected advantage, we need to know it. Here, there's nothing unexpected, though, so that's why, again, we're going to come out to be as obvious on the case, regardless of the inventor testimony.
Thank you very much. So, Dr. Beckerto from EPO, please.
Thank you very much. I think it's very much the same. I already explained the application of our problem-solution approach and the notional person skilled in the art. So it doesn't matter whether something is written as a comment or as a statement in the document or not, and it's not relevant what the inventor might have had in his mind when making the invention. Difficult to define that point in time anyway, but it's an objective we apply it as an objective test. And therefore, I would also assume the opponent relying upon that piece of evidence to come up with a line of argument explaining that regardless of any statement that this is an obvious technical problem stemming from the technical differences between the claimed invention and A4, that this would be rather a line of argument that would be required if it's not already taken as evidence. However, what we would not do, just to underline this, we will not enter into any ex officio questioning on this. Either the case is made by the party relying upon that, or it's not. And if a party chooses not this way, not this line, then the party may lose. If the opponent is not able to present this as a technical problem that the person skilled in the art would then look for a solution, then it might be difficult for winning the case and getting the patent institute revoked. However, this case, I think, for me, is rather a clear-cut case, and therefore I come to the same conclusion as my learned colleagues before. Thank you.
Thank you very much. So this has been answered by the different board. So Morifuji-san, please. So as for the 5A, JPO, unless otherwise stated in the evidence, we consider it to be possible that this is going to be taken as evidence. But answer from both the USA and USA was no. And in conjunction with the answers to number 4, USTPO, including the statement for the question number 4, have made his statement that it is no, and also the objectiveness of the things that we have right now would be emphasized. So for the question number B, both said no, meaning that it doesn't have any direct impact on the answer to the previous question. So we are all in agreement. And I have a question to Tiani-san of USTPO. In your answer, the 0009 paragraph or the specification seems to be important for your judgment. And if there is no 0009 paragraph in the specifications, does it change your conclusion?
It still has figure 5 in there as prior art, so it's not just the one paragraph 009, but it's rather the totality of teaching. Now, if they didn't have a teaching in the specification at all of the prior art, then we don't have the protrusion at all, so that would change us.
Thank you very much. And then this is the end of the question number 5. Thank you.
Okay, so I continue to ask a question about invalidation reason 2. Assuming that the configuration E in the claims of the patented invention had been the configuration EW prime from the original filing, the underlined parts are the parts changed from the configuration E. Does the claimed invention in this hypothetical claim have the reason 2 for invalidation? JPO Chief Judge, Mr. Morifuji, would you please answer? Okay, thank you. So in question 6, configuration E has been changed to EW prime. The part added by this change is capable of draining water through a through hole without hitting the flap. This description is a description that attempts to identify an object by its function. In JPO practice, when a claim refers to an action, a function, property, or characteristic to specify an object, in principle, the description is interpreted to mean all objects having such a function and other characteristics. Therefore, that this statement is to be interpreted as meaning that each component of the lid is everything that has that function. With regard to the specific configuration regarding the function of discharging water from the through hole, the description of the patent in question shows that the through hole is designed to be large enough to discharge water in the storage container and to prevent the discharge of foodstuff in the storage container. Based on the limited functionality of the configuration, compare the invention in the hypothetical claim with the A4 invention. The fact that the A4 invention has a problem of leakage means that the size of the through hole is large enough to allow water in the storage container to pass through. If this is the case, there is no difference between this invention and the A4 invention in terms of the through hole. Taking all of these into consideration, the differences between the invention claimed in the hypothetical case with EW prime, and the A4 invention are substantially the same as the differences between the invention claimed in the present invention with E and the A4 invention. And the lack of inventive step for invalidation reason 2 is also established for the invention claimed in the hypothetical claim. That is all for me. Thank you very much. So now, Dr. Beckett-Olf from EPO, please.
Yes, thank you very much. The conclusion is exactly the same. I would still come to deny the inventiveness of the claimed invention. Why? Because this feature that is now added in A prime 2, it's an effect. It's an effect that is put into the claims. And effects in the claims do not matter when it comes to the assessment of inventive step as a matter of principle, unless there are structural features that are connected to that. As there are no constructural or structural features that are connected with that, it doesn't make any difference. The structural features were already there before the amendment to the claim was made, and therefore this addition, this amendment to the claim would not change the assessment as to the original claim. Thank you.
ありがとうございます。
Okay, next, USPTO, Dr. Tierney, please.
Yes, and it's the same answer you've been hearing. The language being added is intended use. That's how we phrase it. You look to see whether it actually has a structural component required. And secondly, if it does require a specific structure, is that structure any different than the prior art? So here, to the extent it requires a hole that has to be big enough for water, the prior art already teaches that. To the extent the flap has to be in a certain position, it's no different than the prior art. So even if we were to construe the claim as having structural components to it, but with this new intended use, there's no distinction with the prior art, so it would still be rendered invalid.
Okay, thank you very much. We have now all the answers from all three offices. Chief Judge Morifuji, would you please comment? Thank you very much. JPO, USPTO, and EPO all have the same answers. So for the invalidation, reason for invalidation that can be established, so we are all in agreement. However, for the reasons for invalidation, I think this, seems to indicate the characteristics of each office. JPO interprets the added limitation to mean that each component of the lid has all the relevant functions. JPO then concludes that there is no difference between this invention and the A4 invention with respect to the through hole. USPTO has taken the position that the added limitation is considered an intended use or result of the claimed invention and is not structurally distinguishable. I understand that EPO takes the position that the added limitation describes a purpose or effect that constitute a functional feature and does not by itself constitute a distinguishable technical feature or structural feature. So therefore, it's not considered because there is no structural element. So the result is the same. However, for the claims, I think that that indicates the characteristics of each office.
So I think it's tough for the patent owner. So regarding these hypothetical cases, so we have to So we have to consider how we can improve to maintain the patent. So we would like to consider from the patent owner viewpoint. So I think remember the through hole is that the patent owner said she used a drill to make the size. And if that's the case, diameter is 1 or 2 meters if the hole is made by herself. But in the paragraph 19 of the description, the hole size says 10 to 20 millimeter. That is the appropriate size. That's what it said. And this invention and the A4 hole, the size is different by 10 times. So regarding the diameter of the hole, if we limit it to 10 to 20 millimeter, and this patent has a feature to make the size larger to drain the water smoothly. If that is the case, do you think we can recognize the inventive step? Let me repeat once again. So this patent diameter, if it is limited to 10 to 20 millimeter, that is something we would like to consider. And the S, container S, the size of the hole is about 1 to 2 millimeter. When we have such a gap, can we recognize the steps of invention? USPTO, Dr. Tiani, could you share with us your thinking?
If S is limited to 1 to 2 millimeter and the claim requires 10 to 20, you're going to need another piece of prior art to help out or show that why you would modify the hole. I'm not aware of anything in the record to show such a modification, so it appears by limiting it down to that amount on this specific record, it would be patentable. However, it probably obviously do 10 to 20, but we don't have it in the record.
Usually, as you know, usually the EPO is rather generous in allowing amendments to claims, depending upon the state of the procedure. The later it comes, the more difficult it gets. However, the problem here may not now lie with the what we call the whether this is an extension vis-à-vis the original application, but the question is, what is the technical effect of the particular size? Does it make the claimed invention in any way different from other state of the art? And there would be a need for the patent proprietor to explain where this technical idea comes from and what should be achieved over the prior art. If it's just a deliberate choice without any technical backing, then I would rather not consider this as something that could make it inventive.
I see, thank you. So for JPO's opinion is the through hole size, it's possible to change that if there is no evidence and the advantageous effect, if that is proved, if we add the limited factor of the size, there's a possibility that it has a patent feature. But as EPO said, can they prove that effectively? It was a simple case, so we do not know what will happen in the real world. But theoretically, they should show the differentiation, and if that is the case, that will be patentable. So from questions 1 to 6, we listen to USPTO and the ETO's idea, and of course, our discussion was not perfect, but we would like to conclude today's panel discussion. So I said so many issues, like examination, oral proceedings, and the lack of novelties. So I think we were able to deepen understanding. So I hope this panel discussion will be your good reference going forward. USPTO Dr. Tiani, EPO Dr. Beckedorf. So thank you for answering questions in a very easier way to understand. Thank you very much. And this will conclude panel discussion.
Thank you very much, Judge Morifuji and other panelists on the stage. Thank you very much again for your active participation in the discussion.